fights with passion, and he inspires.
Are you ready for a war?
All right, welcome back to From 8 Arbitration, Monday edition. I was going to do one yesterday. It took me forever to pull up the sites for Fay to Meet standards because most of them are expedited, and you can't use expedited arbitrations. You can't use those. You can't put them in an arbitration for persuasive value, and they won't pull up on the database. And so, yeah, I spent all night trying to just find a few because there's hardly any you can use. And so I found some that I really like, and so we're going to do that today. I'm going to do two things today. I said three. I'm going to do two because one of them is going to be really long, and that's questioning supervisors. Got a lot of stuff for that one. And so next Tuesday, I will not have one Sunday or Monday. I have one next Tuesday because I'm going to be out of town. I'll have one on the past practice of things at the case and also employer claims, because I had somebody reach out to me today saying that a carrier in their office was walking across a yard. Somebody had just paved their driveway, nothing on there showing that it was paved, no tape, no nothing, and the carrier walks across the driveway, and now they're trying to make them pay for it, a couple of grand. Problem is, the supervisor tells the carrier, if you don't pay for it, we're going to discipline you. So I'm never paying for anything. You can discipline me all you want. I'll beat that discipline anyway because you're not going to be able to show that it was intentional what I did. There's nothing showing that it was just paved, and I'm doing my job. And so there's no willful intent to do anything. And so we're going to do employer claims, all right, and we're going to do past practice things at the case. Today we're going to do Fay to Meet standards, disciplining us for Fay to Meet standards, because I think that all that's coming. I do. I think that management is way ahead of us, like I've been saying. You have the hour office time, testing the waters. That's what I believe. I could be wrong. Testing the waters, what is the union going to do? Are they going to take it national level on this hour office time, this metric? Are they going to raise hell about it? Are they going to grieve it? And we didn't do anything nationally. And so what do they have now? 45 minutes of office time. And to me, as far as I know, nothing from any business agent. I've not had anybody send me anything. Normally people will send me something. Hey, my business agent's all over it. Don't have anything from business agents. Then you've got management trying to force this 5-minute PM office time. That's age old, though. We've been fighting that forever. But it's setting us up, especially when you have a joint process, a route process, and you're telling carriers to get out of the office in 45 minutes. You're saying you got 5 minutes of PM office time, and people say, just grieve it. We've talked about that. Grieve what? What do we grieve? If I'm in an AO, if I'm in a small station out in nowhere, what do I grieve? I need some help. I don't know what contractual provisions to use. And so these smaller stations get the shit beat out of them. And so that's the reason I can't wait for Paul Bolanger to get in there as Director of Education, because those things will be addressed. The smaller stations will be addressed, and that's something that's personal to me. So then you have them failure to meet standards. We're going to discipline you for failure to meet standards. All right? All of this is tied up together, I believe. So we'll get into that. First off, Branch 73, Atlanta. We went there last week, had a fantastic time with some people that were extremely aggressively ready to fight. They were, I talked about a street fighter. We need a street fighter right now more than ever. And before and afterwards, they were on fire, man. They were on fire looking for change. And so we had a fantastic time down there. Afterwards is always great when you're able to meet your brothers and sisters from different branches around the country. I love that. And a lot of great conversations about what's coming. And they're excited. I'm excited. And James Henry and Kamitra Simpson-Lewis and I went there, and we had a great time. So thank y'all for your hospitality. And we're going to get to a lot more places, a lot more. And we'll go back there. We'll go back there as well. Today, if you got Facebook, you saw that, and you're a friend of mine, had a very special celebration for a guy named Richard McDonald at my station. Now, Richard McDonald started 2 months before I was born. I'm 56. He started at the post office 2 months before I was born, and he looks better than me, which isn't saying much, but he is in great shape. He just had his 60-year, they celebrated that 60-year celebration, counting his armed forces. And so, what an outstanding guy. I love Richard McDonald. I love that guy. He's on Route 9, and I'm on Route 11. And so we've been next door neighbors for 25 years. And to say this dude is probably the greatest carrier ever is an understatement. I don't honestly remember him ever calling in sick in 25 years. He had one health issue. He was forced to take leave. He was forced to, so they could clear that up. Matter of fact, we thought it was pretty bad, but came back. He beat whatever he had pretty easily, but he was forced to take a little time to deal with that. I don't ever remember him calling in sick. He's on the ODL, works every Saturday, and so the greatest carrier to me. His route was always overburdened, heavy mail. I'm talking about a lot of mail, and never complain. Come in every day, do his job. Rarely ever called in sick. Dude's just the epitome of a great carrier. He's unbelievable. And so we appreciated them coming down. I don't normally say good things about management, but they treated him first class today. They treated him, it was spectacular. The AVP come down. She was extremely professional and treated him like that. It was all about Mac. She made sure of that. She was very funny. And talked about his family who was there. So kudos to her. I've never seen her before, and but the AVP, she was really, really first class. And all I've ever said is treat my people with respect, treat us fairly, and we're going to get along great. And they did. The district manager came in, same way, did a fantastic job with Mac, and my carriers are very protective of Richard Mack. My carriers are very protective of him. Nobody will ever say anything sideways to Richard McDonald, and they will get bludgeoned. It's just they are very kids' gloves with Richard Mack, and we all love him. But had a fantastic time there. They provided breakfast for us, and so I really appreciated that. Like I said, I don't normally say good things about management because there's not much good to say about them, but they did great today, and I let them know I appreciated them doing that. But so Richard Mack, 60 years of service, isn't that crazy? And the AVP said she had just gotten back from Oklahoma, where a lady was 65 years. So it's a good job. It's a good job. We're going to make it much better when we take over, make sure this working environment on the workroom floor is taken care of, and some other things, but education-wise, we'll get it back to where people really, really enjoy coming to work, and that's a promise from me to you. So, Branch 73, again, thank you. Thank you for the hospitality, all right? And so, I'm going to get these two things today. I also had somebody reach out, which this was bizarre, and I may do one on guaranteed time, 8 hours guaranteed. Said that they had come in after the route. There was no mail, there was no work to do, and they were about 20 minutes early and before their 8 hours. About 4 of them. So they're just sitting there, and the supervisors, what are y'all doing? Well, we're sitting here waiting on 8 hours. You can't do that. Y'all need to leave. Well, no, we got, guaranteed 8 hours. No, you need to take annual or sick, and you need to get off the floor. So they file a grievance and lose it at informal. And they lose the grievance. And, they're sending me all these text messages between the informal and them saying, hey, what is the deal? And the informal's like, well, y'all weren't doing anything. Y'all weren't working. And they're like, there was no work to do. There's no mail. And we're guaranteed 8. We wanted to stay. They forced us to take leave. Well, that was the settlement. Y'all can take either annual or sick. So that's what we did. There's like, we didn't want to take any leave. We wanted to sit there. Well, y'all couldn't because y'all weren't working. So, and this person said that they were like, You can file a grievance and let it go up. And who wants to wait 9 months for 15 minutes of leave? And that's where we are. That's where we are. Is that people are actually settling grievances because the grievance system is so broken. And that's heartbreaking. That is heartbreaking. That we are settling grievances because you can get 15 minutes of leave now, or we can wait 9 months and you can get your 15 minutes of administrative leave. So the grievance system is so broken, it has affected everything from the workroom floor up. But don't worry, hey, there's light at the end of the tunnel, because we had somebody from National stand up and say it's not our fault. And so, we're in good hands, because grievance system broken, not our fault though. So, hey, that makes me feel much better. And that's what I told them. I said, don't worry about it. It's not our fault. And so, God, that's how completely asinine that statement is. People are settling shit they shouldn't settle because, hey, I can at least get something now, or wait 10, 11, 12 months and get it. And so, but hey, it's not our fault though. So that's good. That is a good thing, knowing that everything has gone to shit, but at least, thank God, it's not our fault. So that makes me feel much, much better, knowing that we're getting fucked over, but it's not our fault though. So that's good stuff coming from National. Makes me feel good about our choices. And so, failure to meet standards, discipline for failure to meet standards. I believe they're going to see a lot of this, because management is way ahead of us as far as fucking us over. You got the hour office time, like I've been saying. Now it's 45 minutes. I had another CCA contact me the other day saying that management is on the workroom floor telling them that each loop is 15 minutes. They cannot go longer than 15 minutes, and they'll be watching them on the scanner. They cannot take longer than 15 minutes per loop. And they were asking me, where is that? I said, no such thing. We have no street standard. There's no street standard, so there can be no time for loops. And what they'll try to do is this one-day count, making that a demonstrated performance. They'll try to do that shit, but we have no street standard. So there is no time on the loop. It takes what it takes. It will always take what it takes. But that's where we are there. You got ignorance on a biblical scale. Management will never treat us right. They will never, ever treat us right. They will always attempt to fuck us over. And that's what we have to combat all the time when you talk about education. This hour office time, that's them trying to fuck us over. 45 minutes trying to fuck us over. 5 minutes PM office time trying to fuck us over. 15 minutes per loop trying to fuck us over. All of these things they know they cannot do. There's nothing contractual about it, and yet they will still do it. Why? Because if they win 10% of the stations, they've won. If 90% of the stations in the country grieve it and we win, they still win. Because 10% who didn't grieve it, who go along with it, who are scared about it, just like this stupid fool saying that if you take sick leave, we're going to fire you. We know that they're going to lose. They know that they're going to lose. But mentally, what does that do to my brother and sisters in that station? Well, I know they can't fire me, but what if they do? So I'm just not going to use my sick leave because I don't even want to mess with it. I don't even fight with it. I don't even fight that. If they fire me, I know that it's going to get crushed at whatever step. But what if the postmaster says, I want that sent up? What if the postmaster says, I want that sent to the DRT? This removal. And it's been sitting there for 10 months, and I'm out of work because I called in sick one day. Psychologically, that's what they do to us. Emergency placements for nothing. So leaving us out there, when we talked about the seat belts, emergency placement for a seat belt, not having a seat belt on. Well, that's easy to win, blah, blah, blah. Had somebody reach out the other day, said they'd been on EP for 3 weeks. 3 weeks because they didn't have a seat belt on. 3 weeks without pay. 21 days without pay. because of a seatbelt. Do you think that they care about that? That they've affected my livelihood, my ability to pay my bills, my ability to furnish for my kids? Do you think that they care about that? They don't care about that at all. So you know what? I don't care about them at all. When we get in and I make sure these teams are going out, I want to make sure these teams are cold-blooded in the way they handle themselves. They have no remorse, no pity, no nothing. That's why. Because they don't for us. They don't care the least bit. If you're starving, you lose your house, you lose your car. They don't care. Kids go hungry. They don't give a fuck. And so that's what we're dealing with. And then, but don't worry about it, though, because it's not our fault. Right? Failure to meet standards. Discipline for failure to meet standards. I'm going to read this. It's off of Contract Administration Unit Contract Talk, 2004. But it's got great stuff. One of the step 4s in here, pay attention to it because the arbitrators cite it over and over again. Okay? That shows you the power of these step 4s that we go over all the time, and they address it here. Okay? Local managers often attempt to discipline letter carriers for failure to meet standards, whether called 18 and 8, percent to standard, demonstrated performance, or by some other such term. This is never just cause for discipline. NALC and the Postal Service have jointly agreed that failure to meet standards by itself is not disciplinable misconduct. Under the terms of a September 3, 1976 Memorandum of Understanding, the M39 handbook was modified to underscore this point. Section 242.332 now provides that no carrier shall be disciplined for failure to meet standards except in cases of unsatisfactory effort, which must be based on documented, unacceptable conduct that led to the carrier's failure to meet standards. Now, y'all get your pen and paper, because I'm going to go through a lot of step 4s and a lot of sites on these two things I'm dealing with today, on this failure to meet standards and also this interviewing supervisors and managers. A lot of contract language, a lot of sites, and a lot of step 4s. So make sure you get your pen and paper, okay? So that's M39 Handbook, section 242.332. This principle was further reinforced in the July 11th, 1977 Step 4 settlement, M386. Now write that down. When you hear the date, July 11th, 1977, you'll hear that a lot in these arbitration sites, okay? July 11th, 1977, Step 4 settlement 386. Management may not charge or impose discipline on a carrier merely for failing to meet the 18 and 8 casing standards. Any such charge is insufficient. Under the Memorandum of Understanding of September 3, 1976, now M39, 242.332, which we read earlier, the only proper charge for disciplining a carrier is unsatisfactory effort. Such a charge must be based on documented, unacceptable conduct which led to the carrier's failure to meet the 18 and 8 criteria. In such circumstances, management has the burden of proving that the carrier was making an unsatisfactory effort to establish just cause for any discipline imposed. Some managers seem to have the mistaken notion that the rules have been changed since the new DOAS program is computerized, more modern, more accurate, or whatever. We all know that quantitative data in the DOAS program are often wildly inaccurate and fail to take into account many of the most significant factors affecting office and street times. But this argument is usually pointless and unnecessary since, in fact, the rules have not changed. This understanding was confirmed in the July 30th, 2001 National Level Settlement, M1444. M1444, which provides the following. The issue in these grievances is whether or not the Piece Count Recording System, PCRS, projected office time, post, or the Delivery Operations Information System, DOAS, violate the national agreement. After reviewing this matter, we mutually agreed to settle these grievances as follows. Daily piece counts recorded in accordance with the above referenced system, post, or DOAS will not constitute the sole basis for discipline. However, Daily counts recorded in accordance with these procedures may be used by the parties in conjunction with other management records and procedures to support or refute any performance-related discipline. This does not change the principle that pursuant to Section 242.332 of the M39, no carrier shall be disciplined for failure to meet standards except in cases of unsatisfactory effort, which must be based on documented, unacceptable conduct that led to the carrier's failure to meet office standards. Furthermore, pre-arbitration settlement there, dated October 22, 1985, provides that there is no set pace at which a carrier must walk and no street standard for walking. And that's M1444. Regional Award C7368. C7368 by arbitrator Dennis Nolan, who now serves on our National Arbitration Panel, is a good example of how arbitrators should apply these principles. He wrote the following: Finally, and perhaps most importantly, the postmaster impermissibly based the suspension solely upon the grievance failure to meet numerical standards. This is but the latest skirmish in the long-running war over standards. No doubt it would be convenient for management to have a simple test to apply to employees suspected of loafing, and perhaps the 18-8 standard is a fair test. Whatever that standard's merits, the parties have agreed not to use it as the basis for discipline. In C3237, national level arbitrator Sylvester Garrett ruled that because management had unilaterally changed the meaning of the 18-8 standard by adjusting the size and configuration of carriers' cases, it could no longer use the standard for discipline. The parties implemented his award with a Step 4 settlement on July 11, 1977, M386, and we read that earlier. That settlement prohibited discipline merely for failing to meet the 18-8 standard. Instead, a supervisor had to charge an employee with unsatisfactory effort and to document that charge with a specific instance of unacceptable conduct. The Postal Service later embodied the same requirement in its handbook, M39, Section 242.332. It is far too late now to ignore those agreements and rules, yet the postmaster cited not a single specific flaw in the suspension letter he sent to the grievant. If for no other reason, the discipline would have to be overturned because the postmaster did not even comply with the Postal Service's own requirement for evaluating an employee's work. So that's very good. That's on Contract Talk from 2004. That's great stuff. I'd also use I've already talked about M1444. I've got that one printed out. But I like this one because it's twofold. Talks about no street standard. There's no set pace at which a carrier must walk, and no street standard for walking. But it also talks about no carrier shall be disciplined for failure to meet standards, except in case of unsatisfactory effort, which must be based on documented, unacceptable conduct that led to the carrier's failure to meet office standards. So that's twofold. It protects us in the office, right, for failure to meet standard, and it protects us on the street. No street standard. Okay, so that's M1444. Also, M1769, and I like this one. M1769. The subject office efficiency tool is a management tool for estimating a carrier's daily workload. Keyword is estimating. Okay, the office efficiency tool used in the Greater Indiana District or any similar time projection system tool will not be used as the sole determinant for establishing office or street time projections. Okay, so if they're telling you that you're failing to meet standard based off of an office projection, based off of a linear measurement, they're not doing a piece count, a linear measurement, and they say, hey, based on DOAS, your office time is this, and you don't make it, first off, they didn't do a count, and so that will never stand. But if they do it like that, this is what we will use. The office efficiency tool in the Greater Indiana District or any similar time projection system tool will not be used as the sole determinant for establishing office or street time projections. Okay, so that's what I'll use, saying that they're projecting my office time based off of linear measurement, which goes into DOAS, not a piece count. Okay? And this one also talks about there's no street standard. And also says no carrier shall be disciplined for failure to meet standards except in cases of unsatisfactory effort, which must be based on documented unacceptable conduct. So that's M1769. I'd also use that one. Here's M1664. 1664. The Delivery Operations Information System is a management tool for estimating a carrier's daily workload. The use of DOAS does not change the letter carrier's reporting requirements outlined in Section 131.4 of Handbook M41. The supervisor's scheduling responsibilities outlined in Section 122 of the M39 Handbook, or the letter carrier's and supervisor's responsibilities contained in Section 28 of Handbook M41. DOAS projections are not the sole determinant of a carrier's leaving or return time or daily workload. So I'll use that one as well. DOAS projections are not the sole determinant of a carrier's leaving time. Okay? So if they come up again, linear measurement, DOAS is saying that you should be out of the office in whatever time, and I don't make that, and I say, hey, you're failing to meet standard. We're going to discipline you because you didn't get out when we told you to. That's what's going to help us here as well, all right? That's M1664. Here's another one I would use, M00005. M00005. The grievance mail was not counted to determine their efficiency in this instant. Data from the counts were not, nor will they be, used as a basis for disciplinary action. Consequently, the grievance case is considered to be closed. So I'm going to read that one again. The grievance mail was not counted to determine their efficiency in this instance. So anytime management's going to say we're failing to meet standard, they didn't count our mail, this is what I'm going to use. If they're saying, hey, I'm eyeballing that, and you should have been out an hour ago. M5. M5. The grievance mail was not counted to determine their efficiency in this instance. That's a great one. So I've got a couple of sites. One of them I read already. That's Nolan. So I'm not going to read it again. That's the one that they cited. 7368. So I've got two. C01482. C01482. And this is what it states. This is a position of management. The employer contends that the removal of the grievance was dictated by the fact that the Postal Service cannot afford a carrier who is not able to case mail. It is further contended that despite more than the required amount of training and more than usual assistance from both management and union personnel, the grievant has simply been unable to case his mail in the specified time. In fact, he is less than 50% efficient in his casing duties. Also, says the employer, the grievant has not improved as a result of corrective and progressive discipline. His lackadaisical attitude results in unsatisfactory effort due to inattention to duty. The union does not challenge the allegation that the grievance performance is well below the accepted casing standards of 18 and 8. It does contend, however, that the employer erred in disciplining and removing the grievance by failing to observe the agreement of July 11th, 1977. Remember that one? We read that one earlier. The agreement, July 11th, 1977, which provides management may not charge or impose discipline upon a carrier merely for failing to meet the 18 and 8 casing standards. Any such charge is insufficient under the Memorandum of Understanding of September 3rd, 1976. The only proper charge for disciplining a carrier is unsatisfactory effort. Such a charge must be based on documented unacceptable conduct which led to the carrier's failure to meet the 18 and 8 criteria. In such circumstances, management has the burden of proving that the carrier was making an unsatisfactory effort to establish just cause for any discipline imposed. Now remember, that one's M386. M386, July 11th, 1977. M386, all right? Now here's the discussion and findings. It is an admitted and proven fact that the agreement cannot case mail at anywhere close to the 18 and 8 standard. This is the arbitrator. It appears that his inability arises from a memory problem which renders it impossible for him to remember the line of travel on his route and cases. If this is so, it is doubtful that he will ever be able to satisfactorily case a route. Under certain circumstances, it would appear that removal would be justified on the grounds of incompetence. Obviously, the Postal Service is not required to suffer incompetence of its employees. However, the employer did not remove the agreement for reasons of incompetence. Instead, he was charged with continued unsatisfactory effort due to inattention to duty. The agreement of July 11th, 1977, there it is again. You're going to hear it a lot. That's how important now it is. That's M386. The agreement of July 11th, 1977 regarding the discipline of carriers for failure to meet the 18 and 8 standard mandates that a charge of unsatisfactory effort must be based on documented, unacceptable conduct which led to the carrier's failure to meet the 18 and 8 criteria. In this case, the employer did not meet this burden. The record is without a single instance of documented, unacceptable conduct. Therefore, the grievance removal is not for just cause. I'll read that part again. The record is without a single instance of documented, unacceptable conduct. And that's how important that step 4 is, 386. Okay? So there's one. And here's the last one. It's M08462. Not M, damn it. C. C08462. C08462, Collins. It's got several charges. Here's as to charge 2. The union introduced into evidence the following Step 4 grievance settlement agreement in case there, which was executed on July 17, 1977. Same one. By the Service Grievance Division, General Manager James Merrill, and Union President Joseph Vaca. On April 19, 1977, the National Association of Letter Carriers filed a Step 4 grievance alleging a dispute existed between the parties regarding the interpretation of the Memorandum of Understanding dated September 3, 1976, involving the 18 and 8 casing standards and imposing discipline on carriers for unsatisfactory effort. In discussion as to specifically what the alleged dispute involved, it was agreed between the parties that pursuant to the U.S. Postal Service's position outlined in Mr. James V.P. Conway's letter to you on April 6, 1977, the following agreement will dispose of any misunderstanding between the parties. Management may not charge or impose discipline upon a carrier merely for failing to meet the 18 and 8 casing standards. Any such charge is insufficient under the Memorandum of Understanding of September 3, 1976. The only proper charge for disciplining a carrier is unsatisfactory effort. Such a charge must be based on documented, unacceptable conduct which led to the carrier's failure to meet the 18 and 8 criteria. In such circumstances, management has the burden of proving that the carrier was making an unsatisfactory effort to establish just cause for any discipline imposed. The requirement that discipline may only be based on unsatisfactory effort shown by documented, unacceptable conduct that led to the carrier's failure to meet office standards is set forth in 242-332 of the M39 Handbook. It seems very clear from the aforesaid settlement agreement that Gilchrist could have been disciplined for failure to meet the Monsey casing standards only if it was shown that there was documented unacceptable conduct that led to such failure. Here, however, there was no such evidence. The fact that his supervisor may have repeatedly talked to him about his being the last to leave the office for his route, and that he may not have taken kindly to such criticism, does not constitute evidence of documented unacceptable conduct that led to his failure to meet the casing standards. And so they threw out the discipline. So that shows the importance of that Step 4. It shows the importance of the M39 Handbook, 242.332, right? That Step 4 is going to be critical for us. M386. I gave you some other Step 4s there, but it talks about the evidence. Does not constitute evidence of documented unacceptable conduct, and that's what we're going to be looking for when we put in a request for information for any and all information management used to issue the discipline. What documented evidence do we have? You're not going to have any because they're too damn lazy, right? Lastly, this is going to take forever. I hate reading, but you're fixing to get read to a bunch. Okay? This is the interviewing supervisors and managers and MPOs and district managers and whatever. And somebody had reached out the other day saying that they were not being allowed to interview supervisors. I always interview the concurring official, always. I always want to know what they looked at, because when they get to hearing, their position will change once they've been coached up by labor. I want it documented. I want it on the record, what you looked at. That way, when you go to arbitration and they come in there and say, well, I looked at this and this and this, the advocate will be able to shred that up when they go, hang on just a second. When we questioned you back here on this date, this is what you said you looked at. Isn't that correct? Yes. But now, here we are 4 months later, and you've looked at all this stuff. Arbitrators will see right through that, okay? So I'm always going to interview the concurring official. I had an individual the other day saying they're refusing to allow him to interview the concurring official. They'll also give relevancy letters, okay? We covered relevancy letters forever. I got a site I'm going to read about the relevancy letter. And so when the dogs of war, when they start going out in the field, we're going to interview district managers. We're going to interview postmasters and supervisors and stuff like that. Because when you talk about the inconvenience of it all, I want to make sure that district managers are inconvenienced when they don't get any of their people, hold them in check as far as their behavior. And that's how you do it. You want to settle the workroom floor issues on the workroom floor? Get district managers in arbitration. They don't want to be in there. And so we'll inconvenience them. And they'll start addressing it themselves. And it'll be bumpy for a little bit. We're going to be in some battles, some wars. There's going to be some harsh words said to us. But that's all right. That's the reason I want rabid-ass dogs going in there on these workroom floors. And so anyway, I've got some things for you on how to combat that, all right? And some good sites for you, some good sites. But first off, we're going to start with M988. M988. And now any type of, we're going to put in an information request. We want to interview somebody and they don't let us. You'll always have 17 and 31 in your issue statement. Always. Did management violate Article 17 and 31 and Article 19 via M988? That'll be your issue statement when they refuse to allow us to interview whoever. And so that's what it'll be. M988. You have Articles 17 and 31, standard. Standard. That's our ability, our rights, right, to interview people. That's our right. That's what it says. Steward's rights. M988. Recently, a meeting was held with the NELC Assistant Secretary Treasurer, William Young, to discuss the above-captioned grievance at the fourth step of our contractual grievance procedure. After reviewing this matter, we mutually agreed that no national interpretive issue is fairly presented in this case. The subject matter of interviews with supervisors has been previously settled in this case, and it's a national level case. It is anticipated that supervisors will respond to reasonable and germane questions during the investigation of a grievance. There is no negotiated requirement that questions be submitted in writing in advance by either party. Now, how many times have you heard that or seen that? A lot of you have sent me that. They're saying that we can interview them, but they need the questions in advance. M988. M98. There is no negotiated requirement that questions be submitted in writing in advance by either party. Okay? Accordingly, we agree to remand this case to the parties at Step 3. And that's from 1991. That's M988. Now, I've got some sites I'm going to read to you. And this will be good for you to put in your file. One of them does not have a C number, but my man Charlie Miller did it. So I'm going to read it because it's a fantastic one. It shows you the importance of this. Okay? Now, this first one is from Jonathan Monat. Jonathan Monat, arbitrator. It's C28500. 28500. Okay? Management violated the national agreement in JCAM when it denied or delayed the union's request for an interview with Lori Buss. The Postal Service is ordered to cease and desist violations of Article 17, 31, and prior Step B's decisions. The prayer for permissive relief is denied. So I'm going to read his findings and opinion, okay? The national agreement JCAM, Article 17, is unequivocal in defining the rights of shop stewards to investigate grievances and potential grievances. Among these rights are the right to investigate and adjust grievances and problems that may become grievances, The steward has the right to obtain management information and to interview potential witnesses. The branch president in Eugene felt that he should be allowed to interview a staff manager tasked with overseeing the operation of the ERMS system. Now, this is dealing with deems desirable. This issue arose initially in a prior agreement now settled. The union had been seeking a list of supervisors in Eugene who have access to the system and make notations about different employees. Management claims the issue is moot since there was found to be no list, and the earlier agreements in which Gates requested to interview Buss was settled. The union continued to claim a right to interview this manager as an independent grievance or potential grievance under the theory that, while the individual grievance at South Eugene was settled, the question remained unanswered about who has access to ERMS and the ability to add notations such as deemed desirable, because the same problem continues to occur in Eugene. Now, somebody the other day had a question on Facebook on one of those sites about deems desirable. And so I just sent a little clip of what they should ask for. JB did a fantastic episode on deems. You'll always have that one individual say no such things as deems desirable. That's a dangerous statement. That is dangerous because management puts carriers on deems desirable. Arbitrators recognize deems desirable. We have a plethora of arbitration cases about deems desirable. Anybody saying no such thing needs to be educated. There is deems desirable. Okay? So anyway, although management thought the matter ended with the settlement of the prior agreements, it is not management's position to make judgment for the union as to what might be a potential problem to be resolved in the grievance procedure. I'm going to read that again. I love this language. And this is what I always say. Although management thought the matter ended with the settlement of the prior agreements, it is not management's position to make judgments for the union as to what might be a potential problem to be resolved in the grievance procedure. The arbitrator concurs with the union and with the JCAM that it is the union's prerogative to determine whether an incident is a grievance or a potential grievance. The union saw that a larger separate problem may exist. He testified the problem was not solved by the PM telling him Ms. Buss did not flag Eugene employees as deems desirable, and that there was no list of who had ERMS access. Articles 17.3 and 17.04 allows the union steward to seek the information from management even if the information is not found locally. In this case, the problem with access to ERMS and accountability, the identification and determination of EAS employees who have access may be relevant to the union's investigation at its discretion. A list based upon an email list of EAS employees is not conclusive as evidenced by the split opinion of the Step B team on this point. The PM testified that he has corrected every known instance of improper notations in the ERMS. However, such action does not solve or prevent the problem from occurring again, as it often has. The question of who authorizes access to ERMS at the local level is left unanswered. Evidence on the record suggests it is the local PM. The purpose of the negotiated grievance procedure is to resolve disputes at the point closest to the source of the grievance, if possible. The parties agree that they are very good working relationships in Eugene and with Mr. Gates. There is not a lack of good faith by either side. Nonetheless, management saw the issue as limited due to the individual grievant whose case was resolved. There is ample evidence that the union president, who saw recurrence of the problem and who was accountable for ERMS access, was investigating a broader problem still unresolved. Paraphrasing arbitrator Snow, the power of the union to investigate and seek relevant information is intended to be lenient and is rooted in the discovery process in modern legal systems. There are times when relevance of requested information is not known. The arbitrator finds that the union's request was reasonable and separate from the grievance settled. I'm going to read that again because this is what, when you get relevancy letters, okay? When you look at Articles 17 and 31, when it says that we have the right to investigate grievances or potential grievances, sometimes we'll request information. I don't even know if I've got a grievance. I don't even know if it's relevant or not. I won't know until I get that, okay? I won't know if have a relevant grievance until I get the information I requested. And if I do, I'm going to investigate it, and then I'll determine that I do. But it talks about Arbitrator Snow. The power of the union to investigate and seek relevant information is intended to be lenient and is rooted in the discovery process in modern legal systems. There are times when relevance of requested information is not known. The arbitrator finds that the union's request was reasonable and separate from the grievance settled. There is evidence on the record that this matter could have been resolved several months ago at no additional cost to any party. The union president testified that 2 or 3 months before the hearing, in the instant case, he spent 3 days sitting 20 feet from where Ms. Buss was sat during a training session in Portland. It is a conundrum that neither party could arrange the short amount of time needed for Gates and Buss to meet and confer in Portland. This confluence of events suggests that management at least delayed the requested face-to-face interview with Lori Buss, even though there was ample opportunity to arrange such an event at virtually no additional cost or inconvenience. Based upon the testimony of the PM and Gene Bradley, management did not know who was accountable for ERMS access, nor did they express interest in identifying authorized system users. The PM in particular testified that cost of the union's ongoing investigation included replacements for Mr. Gates while he traveled to Portland was prohibited. The arbitrator recognized that the post office must replace Gates for the day of the trip to Portland, an issue in the difficult financial times facing the Postal Service. However, there is insufficient evidence to establish compelling circumstances that would have established economic reasons for denying Gates an interview with Lori Buss. Having said that, the parties have explored face-to-face means that did not involve someone traveling between Eugene and Portland. There are several electronic alternatives which provide audio and visual communication such as Skype, a computer-based communication program, and other forms of teleconferencing. The arbitrator does not conclude that these methods are viable, practical, or preferable to the single-minded positions taken by the parties in this case. As this case is played out, the swift resolution of grievances at the earliest possible level has not been achieved in this case. And so he gave us a cease and desist. Here's another one that's quite lengthy. I apologize. C29144. C29144. And it's Schrage. Okay, it's discussion. At the outset, the Postal Service argues that the grievance should be dismissed under the principles of res judicata and collateral estoppel. The Postal Service contends that 29 other cases directly related to the March 2010 mail counts were collectively adjudicated by the same parties, USPS Connecticut Valley District and the National Business Agent for Branch 19. On July 15, 2010, it goes on to state, in reaching this settlement agreement, the signatories included the following caption: any future grievances related to this exact matter will be disposed of in the same manner. In United States Postal Service and National Association of Letter Carriers, as it stated there. Goes on with regard to the merits. In the instant case, the union requested to interview postal managers Joe Johnson, manager, Operations Program Support, Anthony Impronto, Operations Program Support, and Kim Peters, District Manager. The underlying matter that led to the union's request concerned a dispute over the form used during mail counts. The evidence indicates that the union made its request to interview the above-mentioned individuals on a number of occasions between late March 2010 and early April 2010. On March 29, 2010, the union steward made the following written request of management. I will need to interview Anthony Impronto, Mr. Joe Johnson, and Ms. Kim Peters for the improper use of a 1627 grievance. In addition, the memo making the request stated, I will need union time to grieve that management failed to discuss the counting of mail with all the union presidents. I will need to interview managers Zostek, Mr. Anthony Impronto, Mr. Joe Johnson, and DM Kim Peters for the grievance listed above. I will need union time to grieve that carriers were forced to participate in a mail count during the week of 3/20/10/3/2610. I will need to interview Ms. Anthony Impronto, Mr. Joe Johnson, Ms. Kim Peters for the above grievance. In response to the union's request, the Postal Service requests that the union inform it in writing as to the relevance, does that sound familiar, of the request in relation to the collective bargaining agreement and or to a pending grievance. And that's status quo for these relevancy letters. A March 29, 2010 response from the Postal Service stated, in addition, please provide the date of the alleged incident the union or the grievant became aware of the alleged violation, the location of where this incident occurred, and the parties involved. The union responded on March 29, 2010 as follows. This is in response to the letter I received from you the earlier today concerning my interviews. The 3 interviews that I am requesting are all relevant to agreements I am investigating. 1. Article 3, 541, and memos in the JCAM, incident dates 3/2010 to 3/2610. 2. Article 3, 519, and M39 and M41 and ASM, incident dates 310 to 326. 3. Article 3, 4, and 34 became aware on 3/17. All 3 of these incidents occurred in the Allentown station and involved all the letter carriers scheduled to work the week of 2010 to 3/26. In addition, a March 30, 2010 memo from the union included the following statements. I will need to interview Anthony Impronto, Mr. Joe Johnson, and Ms. Kim Peters for the improper use of a 1627 grievance. Second request. I will need union time to grieve that management failed to discuss the counting of mail with all union presidents. I will need to interview manager Zostek, Mr. Anthony Impronto, Mr. Joe Johnson, and DM Ms. Kim Peters for the grievance listed above. Second request. I will need union time to grieve that carriers were forced to participate in a mail count during the week of 3/2010, 3/26. I will need to interview Mr. Anthony Impronto, Mr. Joe Johnson, Ms. Kim Peters for the above grievance. Second request. In a March 31, 2010 response, the Postal Service stated, I am in receipt of your response dated March 29, 2010. However, this response fails to include the relevance of the interviews with management officials in question. And this is what you're going to see. They do not want to inconvenience upper echelon of management. That's the reason we must do that constantly. So get ready for these things, okay? You had failed to provide the relevancy. Therefore, I must ask again, please provide a detailed response to the relevancy of the interviews for the 3 management officials. So now they want a detailed response. As stated on page 31.2 of the JCAM, to obtain employer information, the union need only give a reasonable description of what it needs and make a reasonable claim that the information is needed to enforce and administer the contract. Upon receipt of this information, I will promptly respond to your request. On April 1, 2010, the union responded, I am in receipt of your letter dated March 31st, 2010, requesting again the relevancy for the 3 interviews I requested. As previously stated, the interviews are being requested to assist the union in determining if agreements exist. Article 17.3, found on pages 17.3 and 17.4 of the JCAM, states that I have the right to interview supervisors and potential witnesses to determine if agreements exist. I have previously furnished you with the article numbers that I am investigating. In an April 2nd, 2010 response, the Postal Service stated, I am in receipt of your response dated April 1, 2010. However, you still haven't abided by the JCAM section 31.2 by failing to give a reasonable description for the interviews with the management officials in question. You have failed to provide the relevancy, therefore, I must ask again, please provide a detailed response to the relevancy of the interviews for the 3 management officials, as stated on page 31.2 of the JCAM. To obtain employer information, the union need only give a reasonable description of what it needs and make a reasonable claim that the information is needed to enforce or administer the contract. Upon receipt of this information, I will promptly respond to your request. Union Steward Joe Mahan, hereinafter Mahon, testified that Postal Manager Zostek never actually denied him the right to the interviews. However, he stated that the responses manager gave him left him with the impression that he was not going to get the interview of the individuals. Supervisor Zostek testified that she did consult with Labor Relations regarding her request for the union to provide her with the relevancy of their request, but she stated that she did not actually deny the union's request for the interviews. With regard to the merits, the Step B decision dated November 6, 2009 provides, at a minimum, guidance in the instant case. The B team considered whether the Postal Service unreasonably delayed the union from interviewing the district manager for a grievance investigation. The B team concluded that management violated the National Agreement, Article 17, when they delayed answering the grievance request to interview the district manager. In finding a violation, the B team cited Article 17.3, which reads in relevant part, Section 3, Rights of Stewards. And he highlights the right to interview the aggrieved employees, supervisors, and witnesses during work hours. Such requests shall not be unreasonably denied. It also cited the Joint Contract Administration Manual, pages 17.4 and 5, reads as follows, and he highlights the right to investigate and adjust grievances and problems that may become grievances, as well as interviewing of potential grievant, supervisors, and witnesses. Specified settlements and arbitration decisions have established that a steward has the right to do, among other things, the following: interview witnesses, including postal patrons who are off postal premises, interview supervisors. In light of the language of Article 17.3 and the above cited provision of the JCAM, it is clear that the union steward has the right to interview witnesses as part of an existing grievance or a part of the investigating into whether a grievance exists, and that such a request cannot be unreasonably denied. However, it is also well established that the union's request must be relevant to the grievance process. In addition, the B Team's November 16, 2009 decision provides guidance. I'm not going to read that. It goes on, in light of the above evidence, I'm persuaded that the union sufficiently informed the Postal Service of the reason for its request to interview the postal managers in its initial letter. A review of the initial letter indicates that the union identified the fact that, in general, it was investigating the mail count, and in particular, it was investigating the improper use of the form used for the mail count. It also identified the time period involved for the particular mail count. As a result of the Postal Service's continued request for the union to provide basis for the request, the union continued to provide similar information. In contrast, a review of the Postal Service's continued request for the union to provide the basis for the request, the Postal Service did not indicate the reasons it felt that the information provided by the union was not sufficient. Moreover, did not inform the union that the individuals that the union requested to interview did not have any information related to the issue being investigated. Similarly, there is no evidence that the Postal Service offered the union steward a clear and reasonable alternative to interviewing the individuals. Therefore, I'm persuaded that the union did provide the Postal Service with sufficient information as to the reason for its request to interview these individuals, and the Postal Service unreasonably denied its request. The Postal Service appears to suggest that it had a right to impose a higher standard before agreeing to allow the union to interview upper-level management. Now, this is the best part about this case, about this site, okay? He's going to get into things that you're going to need when you request to interview upper management, okay? This is very good. The Postal Service appears to suggest that it had the right to impose a higher standard before agreeing to allow the union to interview upper-level management. I have been provided with no evidence as to why the positions held by the individuals would protect them from being interviewed by the union. I can find no contractual directive or other authority for imposing a higher standard upon the union in evaluating its request to interview these individuals. In fact, there was little or no evidence introduced as to the duties or responsibilities of the individuals to establish a basis to insulate them from being interviewed. And all that's beautiful. The Postal Service also appears to suggest that Impronto's call to the union president was an attempt to resolve the need for the interviews. The parties agreed that if Anthony Impronto were to testify, he would have stated at the time of the conduct at issue in this case he was an analyst, Connecticut District, and that he called Union President Mays to clarify the reasons for the use of the form for the mail count. In addition, he would state that the Union President Mays told him that the matter was already in the grievance process. The grievance procedure included in the collective bargaining agreement is intended to encourage grievances to be resolved at the lowest level. Although Mays, as union president, could have agreed to engage in discussions with Impronto, he also had the right to inform Impronto that the matter was in the grievance procedure and should be handled in the normal course of the grievance process. And so he found a violation of 15-17-31. So that's great language. He says, hey, there's nothing that insulates upper management from being interviewed. There's no contractual language that does that. And so that's a fantastic case. Here's another one. It's from Jonathan Monat, 28416. Now this one, it shows the power It shows the power of Articles 17 and 31 more than any case you'll ever read. More than any case you'll ever read. And what it has to deal with is it's out of Guam. And management has changed the method of delivery. Okay? And under the POM, Postal Operation Manual, arbitrators cannot consider any change in delivery. And that's what this arbitrator addresses. Look, it's out of my hands. Because National Arbitrator Menthal said that the POM, Postal Operations Manual, had nothing to do with wages, hours, and working conditions. So I cannot consider those changes because the union was grieving the changes. Okay? And so I'll read this to you, and it'll help you understand what I'm talking about. Dispute resolution team has resolved this grievance. A violation has been shown. Management will cease and desist violations of 631, 631.7 Postal Operations Manual. Also, management will cease and desist violations of Article 31. The file clearly shows management did not seek or receive approval from the patrons in the affected area of Route 26 prior to changing from curbside delivery to CBU. There is a letter in the case file signed by the affected patrons indicating that they were never contacted by the Postal Service about the change in delivery and are in disagreement with it. The patrons stated the CBU is placed in an unsafe, congested area. The signatories to the letter wish to retain the curbside delivery established for the previous 2 to 3 years. Then the arbitrator goes on to talk about how the changes in the POM, and this is what he said. The arbitrator is faced with a conundrum when considering the violation of the POM sections 631.6 and 631.7. The Menthal National Award and progeny held that Article 19 incorporates only those parts of the POM that directly relates to wages, hours, working conditions. If the substance, not the effect of the POM section, is not related or only indirectly related to wages, hours, and working conditions, and the NA is silent on the subject, then management has the right to manage its operations without concern that it will violate Article 19. Applying the Menthal reasoning, arbitrators Eisenmenger and Stevens found that the NA was silent on mode of delivery and therefore a grievance about mode of delivery was not arbitrable. These decisions reflect the common view of arbitrators on this point. This is the basis on which management challenged the substantive arbitrability of the instant grievance. Okay, so that shows you the POM. He's going to take National Arbitrator Menthal, Eisenmenger, and Stevens into account. He's going to say that it's not arbitrable, but he talks about 17 and 31. This is what he said. And this is the importance of 17 and 31. With respect to the second cease and desist order, the arbitrator finds the evidence is clear and convincing that management violated and continued to violate the union's rights to information. This language reflects an earlier Step 4 decision. The definition of reasonable and unreasonable are determined on a case-by-case basis. There is no showing by management either the union's requests were unreasonable. The early decision by the late arbitrator Ben Aaron firmly established that NELC stewards have the right to investigate grievances in a manner permitted by Article 17. Article 31.3 sets out the employer's requirements to make available for inspection by the union all relevant information necessary for the enforcement, administration, or interpretation of this agreement. Included among the types of information covered by Article 31.3 are internal USPS instructions and memorandums, route inspection records, picture complaints, and reports and studies. All of these types of information are available when requested and should have been provided. The original Step B decision found that management failed to provide information requested by the union, including all available delivery requests from Route 26 customers and the Route 26 review. There was no reason for the absence of the information requested from the file. The Step B decision, dated April 3, 2008, remanded the case to fully develop the case file. Stuart Pablo testified that management failed to comply with his request for all motor vehicle accident records. He was denied permission to take videos and was denied time to investigate. He was ordered not to talk to postal patrons or conduct his own investigation on or off the clock, with implied threats of discipline as the subtext. Also, Pablo testified, supported by ample evidence, that the OIC Brunton and others failed to respond or delayed response to certified requests for information. The continued pattern of refusal to provide information and access without any proof or claim that such requests were unreasonable represents an ongoing violation of the union's rights under the national agreement. This is not mere forgetfulness or careless. The facts point to intent to withhold information. In National Labor Relations Board versus USPS, the court said the USPS had demonstrated a proclivity to oppose workers' rights. This case focused on the breadth of remedial orders in such cases. Although this was an NLRB case before a circuit court not including Guam, the fact pattern was generally the same. The Postal Service failed to provide requested information and threatened the steward with discipline, as was implied to Stuart Pablo. While there was no retaliation against Pablo in the instant case, there was a pattern of failing to comply with legitimate information requests, as well as denying Stewart time in order for Pablo to carry out his responsibilities within Articles 17 and 31. The Step B team entered a cease and desist order because the employer violated the steward's rights. The employer continued to violate these rights after the order was issued, including egregious and persistent conduct in refusing to allow Mr. Pablo to investigate this matter on or off the clock. The union's grievance, based upon the failure of management to comply with the first Step B decision, was remanded at the request of management and concurrence of the union in order to provide more information. In sum, the arbitrator finds that by clear and convincing the evidence that management of the Guam Post Office violated the cease and desist orders issued by the Step B team in its decision of December 7th. From all the evidence and testimony, it is apparent that management has continued those violations. The union has requested remedies for violation of each cease and desist order for the violation of the POOM. The union seeks reinstatement of curbside delivery on Route 26. Given that the service continues to violate the order and expand the scope of the violation, an increased remedy is appropriate. Absent guidance on what that remedy should be, and given the apparent willful nature of the continued violation, the arbitrator must fashion a remedy that is meaningful and appropriate. Clearly, another cease and desist order by itself is neither to reward management for its continued ignorance of the requirements of the POEM 631 and 631.7. Thus, the arbitrator orders the Postal Service to restore curbside delivery to all patrons on Route 26 as soon as practicable and to conform to the requirements of the POEM. No monetary remedy shall be offered to the union because it is not proven any monetary to any specific letter carriers. Among the most important rights within the NA are the rights of the stewards to investigate and process grievances, potential discipline, and other matters within the scope of the bargaining under the national agreement. The ability of the steward to work proactively as well as retroactively enables the parties to establish a more conflict-free and productive environment. As Mr. Pablo testified, he had been allowed to investigate, and had he possessed some of the information he now had, he might not have been here. The remedy in this instance must be stronger than a cease and desist order, which management ignored and paid no penalty for its egregious violations. A monetary award is perhaps the only remedy which is appropriate in this case. There is precedent within the arbitral history of the Postal Service of such a remedy. Therefore, the arbitrator awards Stewart John Pablo the amount of $10 for every day he was worked from December 10, 2007, the date of the initial Step B decision, and the date of the award. Now, he just got paid $10 a calendar day from December 10, 2007 to August 21, 2009. Think about that. Because they refused to allow him to interview the manager and supervisors. He sent them a certified letter. I want to interview y'all, and I need this information. Just turned a blind eye to it. So it cost them, because of that, $10 a calendar day for almost 2 years. And what will management say? We're weaponizing the cease and desist. That's what they'll say. We're weaponizing. We're not going to correct ourselves. We're not going to dress ourselves as far as the things that we're doing. We could have just given him the information. We could have just given him the investigations, the interviews. We could have just done that. We didn't do it. We intentionally did it. The arbitrator even says it. It was intentional. And so whose fault is that? According to Barner and the Postal Service, it's our fault because we're weaponizing things. According to the director of retirees, it's our fault. Right? Here's another. And this is Charlie Miller, the one and only. And he sent me this one to go over. But this was and related to discipline. Okay? It has no C number, but it's a great decision. I'm going to read it. The arbitrator's decision. It's very short. Opinion. And this is arbitrator Michelle Miller-Kachula. It has no C number yet, but when it does, you need to get it. The issue to be determined as stipulated as to whether or not the Postal Service violated Articles 16 and 17 of the National Agreement and Section 115 of the Handbook via Article 19 of the National Agreement when they issued letter carrier Xavier Franco a notice of removal dated 9/23/24 charging him with unacceptable conduct. If so, as the appropriate remedy, review of the relevant record establishes the following material facts. And then she talks about the Postal Service position, the position of the union that the removals were not for just cause. The agreement admits to being involved in a verbal dispute with the customer and regrets what occurred. However, he sought EAP help, which is favorable. The union raises the issue that the agreement's immediate supervisor is not the issuing or concurring official. The agreement's due process rights are violated in this instant case because despite the union making multiple attempts to interview the issuing and concurring officials, such requests were not granted and the Postal Service did not fully cooperate with the union. The union concludes as a result, the agreements must be sustained and the agreement be made whole. I have carefully considered the arguments of the parties in conjunction with the relevant facts and the language of the National Agreement. The record shows the agreement engaged in a verbal altercation with the customer on September 10th. He used profane language with the customer and such altercation was caught on video. The agreement did not dispute these actions on day in question. Since that time, he has expressed remorse and attended the AP. After the agreement was disciplined on September 23rd with a notice of removal, the union filed a grievance. The evidence shows that the issue moved through the grievance procedure. The union asked the Postal Service to interview the issuing supervisor, who is the manager of customer services, SDC, Riverfront Station, as well as the manager of customer service operations for San Diego, who is the concurring official. So we put in an information request. We want to interview the concurring official, which is a fantastic idea. The union made this request 3 times, but was not provided with the opportunity to interview either person. The steward also left voicemail messages for the concurring official, which were not returned. It was contended by the union that the agreement's due process rights were violated since the requests for interviews were not granted during the grievance process. The parties have developed language in their national agreement as well as procedures in the handbooks and manuals instructing how to deal with grievances. One of the key components in processing grievances is for both parties to have the opportunity to develop their case. Stewards are given the right to review documents, files, and other records necessary and shall have the right to interview the aggrieved employee, supervisors, and witnesses in order to process the grievance. The steward is granted these rights on behalf of the union to develop the arguments and contentions. Part of this investigation is to review the file and decide what else is needed. This is necessary to ensure due process for the grievant and that a fair and thorough impartial investigation occurred. Interviews with the issuing concurring officials may be used to determine if they independently reviewed the facts, acted without bias or undue influence, and found that the agreement had a fair opportunity to respond to the allegations against him before deciding on the appropriate level of discipline. In this case, the record reveals that the steward asked to interview the issuing and concurring official on October 3rd, October 6th, and October 7th, and left voicemail messages for the concurring official. However, he was not given the opportunity to interview either of these individuals despite his repeated request. It is my opinion that the Postal Service denied the grievant his due process rights by not allowing the steward to interview the concurring and issuing officials while the grievance was processed. It was necessary for the steward to have the opportunity to determine if discipline imposed on the grievant as a notice of removal was based on a fair and impartial evaluation of the facts, in accordance with the collective bargaining agreement, the just cause standards, and the grievance due process rights. The union steward asked to have him interviewed on several occasions but was denied the opportunity. The union, in my opinion, was unable to fully develop the case to defend this grievant. By not allowing the union to interview the issuing or concurring officials as requested, the Postal Service failed to give the union the opportunity to conduct its fair and objective investigation, which is a fundamental requirement under just cause. The grievant was deprived of his due process rights. Without adherence to basic due process, The Postal Service decision cannot be sustained in this instance, and is therefore the arbitrator's determination that the Postal Service failed to meet the due process standard. The union was not afforded an opportunity to interview the issuing and carrying officials during the investigation, despite repeated requests. The individuals requested to be interviewed had the ultimate authority to determine the outcome of the grievance employment, yet their decisions were not able to be reviewed by the union as requested. A denial of the grievance right to due process occurred in this instant. The union could not verify whether the officials reviewed and concurred on the investigation file, understood the facts of the case, considered any mitigating circumstances, or whether they simply made a recommendation without the evaluation of the entire record. Therefore, I find this discipline imposed on the grievance was procedurally flawed and cannot be sustained under the just cause standard. So there's you some fantastic sites on our ability to interview upper-level management supervisors and managers. All right? You've got a good step forward. You always use 17 and 31. Some great sites. I may have some more for you next Tuesday, okay? Because it's important. It's going to be really important coming up, because once we get in that ass when these dogs of war go out, it's going to be extremely important. Extremely important. So I may have some more sites for you next Tuesday, okay? I probably will. Even though it's boring as hell reading, and a lot of y'all reach out to me and say, God, that's so boring. I agree with you. It's boring as shit. But how I learn, most of what I learn, is through reading B-Team decisions and arbitration sites. That's how I did most of my learning, or early on, was reading. As boring as that sounds, reading, and reading. All right? And so that's just how I learn. So I have some more sites for you next Tuesday on that. It's important, and it's fixing to be really important, like I said. Going to talk about the past practice of having things at our case, because management's starting to come in there just for no reason other than to fuck with us to take things off our case. I'll have something on that. And also, what was the last thing? Oh, yeah, employer claims. We'll have some on that too, okay? And that will be next Tuesday. Remember, I will not have one Sunday or Monday. All right? So, next Tuesday. If I don't ever have one on Sunday, something's happened. All right? Y'all got me for 8 more years. Okay? So, I'm not going anywhere on From 8 Arbitration for 8 more years. 8 more years, I'll tell y'all goodbye. All right? But I'm not quitting this. Even when we win, I'm not quitting From 8 Arbitration. Okay? And so, those of y'all who are glutton for punishment and still listening to me, you got me for 8 more years. Okay? And then I will tell y'all goodbye for the last time. All right? I love you. I love you, Light Blue. And I can't wait to get in there and settle some shit. Okay? Y'all have a fantastic week. It's going to get very rainy here. So everybody be careful. Everybody be careful. Help is coming. Help is coming. I promise you that. We are coming. Okay? And there's not shit anybody can do about it but sulk and get boxes and some good box tape. Okay? Because they got a lot of heavy shit they're going to put in those boxes when they're clearing out their fucking offices. And I'm talking about resident officers, business agents. Got a lot of shit they're going to put in those boxes. So get you a good box tape, a good sturdy box. Okay? And U-Haul has those. If y'all are going to be looking for shit, U-Haul has some good boxes with some good box tape. And get that so you can get your funky ass out of the office and let real people in there that know how to fight, okay? So I'll talk to y'all. I'll talk to y'all next Tuesday. See y'all at the rap session Friday, all right? I'll be there. Y'all come holler at me. Rap session Friday. And I'll talk to y'all later, all right? I love you. Bye.